We're waiting for one person, and we'll give her another minute. If not, we'll continue.
Oh, you know, when you're gone for 3 days, you lose a lot of, you just get so far behind.
Before we get started, I'd like to welcome everybody for day 2. The live stream is on, and we have interviews till noon today, and then we will deliberate after lunch today, and then we will vote and send the names to the governor. With that, we already have Mr. Nierman here. He's sitting there for a while, and you should be comfortable, so we're ready for your opening remarks whenever you want to begin.
Thank you, Justice Wiggins. Commissioners, good morning. I'm here with my wife, Lisa, and we've seen a lot of years together. It's just great to have her here, and we have 2 amazing children that are rooting us on from home.
Welcome, Ms. Nierman.
When I was in grade school in the 1970s, I did what my best friends did, and that is I watched too many police shows on television. As a result of that, and a lot of other things, I developed a dream of growing up and helping to save people's lives. But as my career plans changed from law enforcement to law practice, I didn't know that my dream would be realized in an unexpected way. And one of those stories includes some insights on how I view the law. Several years ago, a lady in her 60s was in imminent danger of having a severe brain aneurysm. Physicians at a research hospital were ready to implant a small device that held the hope of saving her life, but her insurance plan denied pre-certification, asserting that the procedure was experimental. She didn't have a 6-figure cash payment to go forward, and so she came to me. I filed for arbitration under the statute, and the disinterested physician that reviewed the case agreed that the procedure was indeed medically indicated, medically necessary, but also stated that it was experimental and denied the claim. But at that time, before the statute was substantially revised, stating that a medically necessary procedure was experimental was not a valid reason under the statute to deny a claim. Once we appealed through litigation, the insurance plan realized what was going to happen and agreed to go ahead and pay for the procedure. And at last report, a client was fully recovered and enjoying time with their grandchildren. Sometimes when I think about that case, I ask myself, was justice accomplished? You might say that she got justice, but if it was justice for her, wouldn't it also have to be justice for the insurance company? And what about the carrier that clearly excluded experimental treatment, but was forced to pay for it anyway? These are hard questions, but for those serving in the judiciary, the analysis is straightforward. Judges are called to render a legal decision in accordance with the Constitution, decisions by superior courts, and valid acts of the legislature. This is borne out in Iowa's judicial oath, which requires judges to, quote, administer justice according to the law. I've had dreams come true. I've also had times when I gave up what I wanted. Sometimes we have to forego our own desires to help someone else. Similarly, if I am so fortunate to take the oath of office, I will do so with a clear conscience, knowing that I'm ready to let go of my own preferences to faithfully apply the law.
Thank you, Mr. Nierman. We'll do questioning. We'll start with Mr. Gray this morning.
Could you tell us, sir, what particular talents you have that would lend itself to the Iowa Court of Appeals?
Yeah, it's a great question. I think there are several really key components to a great appellate court judge. Intellectual ability, collegiality, strong work ethic, and varied experience. And I believe that I bring all of those. And I may be happy to go into detail in each one. I don't enjoy talking about myself, but you know, I think it's really important that we fit the right person with the right job in the judiciary. And I think it's essential that each person, before they apply to become a judge, take a careful look at who they are and where they would best fit, how they can most contribute, what is their sweet spot. And I've done that, and for me, the answer is clearly the appellate courts.
Thank you.
Mr. Halbach.
Thank you, Justice. Can you just, we had this discussion while we interviewed, but could you recap for me again, you're going to see a wide array of cases and your ability to have some areas of expertise, talents, experience that would lend you to be able to have such a broad scope on the Court of Appeals.
Yeah, my practice has been both broad and deep. So when I started practice a couple decades ago, I was doing a lot of real estate, probate, transactional work, and then eventually started with litigation, some insurance claims, but also a significant amount of criminal work, domestic relations, and juvenile work. And so I've seen a really broad variety of cases, and so you know, I'm going to see things that are familiar. I also talked about the practice being really deep. So right now, I have a pretty highly specialized practice, and I think that's also significant. You know, there are insurance cases that turn on kind of minute, discrete facts. And I know that my area of law is really complicated. And so when I have a criminal matter, when I have a probate matter, and you know, insurance cases touch those areas and more, I know that those areas are also complicated and require me to become an expert on those. It makes me think of a case I handled years ago. It was a contract dispute, and it involved the purchase of civil defense sirens. I had to become an expert in civil defense sirens. The case I talked about in my opening statement, I was over at the University of Iowa Medical Sciences Library going through journals and figuring out what the researchers have said about this procedure. And so this ability to know that I don't know something and then find out everything I need to about that subject will serve me very well.
Thank you.
Ms. O'Brien?
No questions.
Ms. Roberts?
No questions, thank you.
Mrs. Conover?
Questions.
Mr. Bloom?
We had some discussions in our earlier interview for the Supreme Court opening, and we talked about respect for the law and consistency, and that your concerns that the electorate, or there was an apathy growing. Could you just sort of expand? Maybe it's a little different question now in the Court of Appeals, but could you just talk a little bit about your concerns there and how you see this opening, or your ability to maybe stem that apathy?
Sure. So yeah, this is a somewhat different question because the Court of Appeals is, you know, largely just applying existing precedent, and you know, just needs to do that regardless of you know, the judge's personal opinion about whether the precedent is right or wrong. You know, we do have a problem in this country of voter apathy. You know, in this last midterm election, there was a lot of press conference coverage about how voter turnout was exceptional. Nationwide, I mean, it was exceptional compared to prior years, but nationwide it was just slightly over 39%. I mean, that's an F. And I think, you know, one thing, you know, courts need to make sure that they are giving effect to valid acts of the legislature. And, you know, ideally, the legislature is implementing the public policy. And, you know, that gets to the roots of democracy. People govern. They do that by hiring legislators, and with the expectation that legislatures will do what they want them to do. And if legislators don't do that, then the people fire them and bring someone else in. But if people don't vote, then we don't have a democracy, and that's very dangerous.
Okay, thank you.
Mr. Goodman?
Thank you, Your Honor. Thank you very much for your application. I was interested in your opening statement and the case that you had that went to arbitration. I'd like to know, based on that experience and the experience you've had, I think from our discussions on both sides of the insurance industry, I think you were an adjuster at one point in your career and subsequently have represented private clients against insurance companies. Do you believe that arbitration is the best method for resolving disputes between individuals and insurance companies, as opposed to being able to file those claims at court and adjudicate them with a filing fee of $150?
Yeah, that's there's a lot to that question and answer. The particular statute that I was referring to, 514J, gives patients and insurance companies a very inexpensive, quick way to resolve health plan disputes. Essentially, the application is made to the insurance commission. The insurance commissioner hires a physician, usually out of state, to review the documents and make a decision that, for most cases, is binding. And now that the statute has been substantially altered, it almost always is the final decision. So I think in terms of whether we should expand arbitration or not, that's in a sense a public policy decision. I do see at least some limited forms of arbitration that are advantageous to both sides, and I think 514J is one of them.
Okay, thank you very much.
Ms. Diekma?
Thank you. Mr. Nierman, you have been hired by attorneys to act as an expert in cases. I'd like to know whether or not you think that's helped you in your practice, and whether or not that's been something that has kind of had you see different side to things.
Yeah, absolutely. I've been deposed many times as an expert witness, and so now when my clients are about to be deposed or cross-examined, I can tell them, I've done this. This is hard. It's hard having an attorney that's against you, asking you tough questions. I've had some great experiences. I've gotten to travel around the country, testify in other courts, and it's really opened my eyes to different ways of handling judicial issues, and so it's been an extraordinary experience, and one that, I think has very much sharpened my skill set. And in a general sense, I think it's really important that we have, of the 9 judges of the Court of Appeals, it's important to have within that team a variance of experiences, abilities, perspectives, and that's one of several things that I bring that may well be unique.
Thank you.
Ms. Sinclair?
No questions.
Mr. Sukup?
No questions.
Mr. Bevel?
Yes. Could you tell us about what kind of your criminal defense work? What kind and how often?
Sure. Largely, that was earlier in my career. I've handled some felonies, taken some cases to trial. I never had a huge criminal defense practice. It's interesting. Some of those cases, though, have meant a lot to me. I've had people come in to my office and say, wow, I really messed up my life and I need help. And I've also had a few people come in and say, I did not do this. I was wrongly accused. And it turned out in a couple cases that they were absolutely correct, and we got to take those to trial or had them dismissed, and it was just so meaningful to them. For me personally, excuse me, the harder ones were, hey, here's a bunch of money, get me off. I turned some of those down. There were a couple where, maybe that was true, but there were some compelling circumstances about how things were done. But I think it's very important work. Obviously, it constitutes a very significant portion of the Court of Appeals document, and that familiarity is going to, I think, will help me greatly.
Thank you.
Ms. Law?
No questions, thank you.
Mr. Diaz?
Mr. Nierman, are you a better fit on a district court level or the Court of Appeals, and why?
Yeah, thank you. I think we have a kind of some competing views of what the judiciary is, and maybe if I could just talk about the extremes for a moment. I don't think anybody's really at the extremes, but at one extreme, the courts are a hierarchy, and everybody is there's kind of this polite race to get to the top so that they can control the law and so forth. On the other extreme, the judiciary is a team, and there are a number of different roles. Each role requires a slightly different skill set, or maybe a significantly different skill set. And I think it's really important that before someone applies, I think I mentioned this before, that they took a really close look at who they are and where they fit. We have some great trial judges, and we have some trial judges who know that they are in their sweet spot, and that's where they need to be. I'm applying for appellate court positions because that's where I believe I need to be. That's where I'm going to contribute the most. And when I look at how I think, my gifts and abilities and so forth, it's very much the appellate court. Did I answer your question?
Have you ever applied for the district court,
I have not applied for the Iowa District Court.
and it was for that reason, or? for
Yes,
other-
absolutely.
Thank you.
Mr. Berger? Ms. Bowden?
Yes, thank you, Mr. Nierman. I have talked to you previously and reviewed your application. I admire the variety of cases you take, the clientele, the smallest person to the big business. You've worked for an insurance company, you've been in private practice. Can you please tell me what the difference is in your skill set working for an insurance company and in private practice, and how that would carry over if you were selected to be a Court of Appeals judge?
So I think, when I was a claim adjuster, back in the old days, somebody got hurt or, some bad thing happened, and I got to, drive out to their farm or visit them in their home and listen to them about how this upset their lives. And it might be our own clients, it might be a client that are insured wrong. And so I did a lot of listening and a lot of hearing about what was really important to them. That has been very valuable to me. And so now when I'm meeting with the clients, they've got a story. Something has happened to them to bring them into my office. And, I need to solve their legal problems. I need to be an excellent lawyer. But I also need to be someone who cares for them. If you ask the average person what they think of lawyers, I think generally you get one of two responses. One is, oh, I hate them, they're horrible. And the other is, my lawyer is awesome. And, I think the people in the former group, by and large, had lawyers that cared about making money, didn't care about them personally, saw them as a means to an end. And I think people in that latter group had somebody who, just genuinely cared about them, wanted them to be healed in a personal sense, as well as to have their legal issue resolved. So, all of those things, I think will help me greatly on the court, listening to my colleagues, hearing about what their perspective is, what's important to them. I end up in a lot of committee meetings, and I often hear one person say, we absolutely have to do A, and somebody else say, no, we have to do B. And I'm often the person in the room listening and thinking, okay, how could we do A and B? You know, if we move things around a little bit, could we do A and B and actually have something come out that's much better? So that's the kind of listening and thinking that I'll often bring to a team environment.
Thank you.
Ms. Pearson?
Good morning.
Good morning.
During our discussion, you shared that while you were in law school, you had an opportunity to teach, and one of the areas that you taught was cases from the Court of Appeals. And would you share with how that maybe early opportunity would add value to the opportunity to serve in that capacity now?
Yeah, so I taught maybe 10 years after I graduated. I'm not recalling, yeah, roughly starting 10 years after. And just so the lawyers and non-lawyers on the same page, the curriculum in law school is essentially appellate court opinions. So law professors are, in a sense, flying at 35,000 feet. I see my time's expired. Can I finish my thought?
Keep going.
Okay. And going around the country, looking at Supreme Court opinions, maybe Court of Appeals opinions, and picking out the ones that best explain the law, that will best demonstrate how the law is developed, and then analyzing those, assigning those to students, and then teaching what they mean. And so, I've, in a sense, had a bird's eye view of how the appellate courts work in that particular field. I think that'll be a tremendous help to me as an appellate judge. And you asked specifically about Iowa cases. So I assigned my students a case book, and I actually thought there were a couple Iowa cases that it didn't include that our students had to have, C&J fertilizer, and I think it was the Ludwig case. And so I created a supplement to include those and a few other things as well.
Thank you.
Thank you, Mr. Nierman. We are out of time. We'd like to ask you questions all morning, but we need to move on. And I really appreciate your application and wish you the best of luck.
Thank you very much.
Thank you.